first of all, I want to thank you all for the invitation to speak to you all today. And I wanted to bring you greetings from our Chief Judge in Washington, Judge Steve Purcell, and our Associate Chief Judge for Black Lung, Bill Caldwell. Some of you in the legal side and the lay representative side may have already heard that Judge Caldwell has announced his retirement on November 1st. And don't ask who the successor will be. I can only assure you it won't be Judge Morgan from Pittsburgh. I've done my time in Washington, so we'll see where that develops. Today I wanted to talk a little bit about the backlog that OALJ has nationwide in black lung claims, and also the smaller backlog that we have here in Pittsburgh. And to give the lawyers and the lay reps, and I suppose it may be of some interest to the medical folks as well, sort of how the black lung process winnows out sort of a triangular form as they work their way through the system from the OWCP level through OALJ, the Office of Administrative Law Judges, up to the appellate body, the Benefits Review Board, and eventually the courts, various circuit courts of appeal that hear black lung cases. And even occasionally, some of you may know, I know the lawyers do, that once in a while, once in a decade or so, a black lung case will actually get up to the Supreme Court. So that's how they winnow out, but that's very, very rare. So we're going to talk to you about that and a little bit about some things that you as lawyers and lay representatives may do to help your clients process their claims and help us decide the claims in a little bit better fashion. Now, some of that may be, some people may say, well, that's the pet peeves of the ALJs, but so I'll share some of those with you. And as my administrative assistant said when I gave her a preview of the talk, she said, gosh, that's a lot of statistics you're giving. And I said, yeah. And she said, well, that's what government employees do. They give the public a lot of statistics. So I'll be giving you some statistics, too. And then we are also fortunate, and I'm blessed, to have an extremely intelligent, capable attorney advisor who works in our office, Mr. Frank Fagan. Now, he's going to be actually providing you all with the brain food and the intellectual side. I'll do more of the numbers and the easy stuff. Our law clerks do the hard work. So some of the lawyers will appreciate that. And it's also nice, by the way, to see some familiar faces in here. Ron Carson, I don't know where he is back there, but I did cases down in Abington, Virginia when I first started with OALJ back in the beginning of 1997. And old Ron Carson, not old John Custer, Ron Carson. Ron Carson helped me very much in those initial black lung claims and did a really bang-up job for the minors that he represented. I can't tell you how much I appreciate the work that the lay reps and the lawyers do in the black lung clinics representing minors. It's noble work. Gosh, they have a heck of a job. I wince sometimes when I hear the minors testifying about crawling for miles in 4-foot coal, and just try to imagine those conditions. And you folks, at least on the medical side, really, I'm sure, get into that. And I was talking this morning with some of the hospice people and end-of-life issues. It's got to be awfully terrible. So I really admire you all for what you do, and thank you. And particularly those clinics that provide lay representation. I guess we're down to 2. So the backlog. The Office of Administrative Law Judges encourages minors and their survivors who are filing claims to get representation, and they can find that on a page, on a web page that's entitled "Cómo puedo encontrar un abogado?" So, if you have issues with the minor and he wants to know how to go about that, just have him check out that site. As far as you might be interested in the legal costs on the claimant side, processing some of these black lung claims, and the latest data I have is rather old. Some of the data I'm giving you is from a government accountability study that they did of the black lung program back in 2009. So the data is old, and the Department of Labor didn't want to put out more recent data on some of these things. So they found out in 2009, they were looking at one law firm at an estimate of black lung cases that took them 2 to 4 years to resolve, and the cases averaged about $18,000 each in total legal costs. And one firm they were talking to had 5 black lung cases that had been active for 7 years or more, and there are some of those still out there that they figured cost them a total of $70,000 in accrued legal costs. So that's a lot of money to handle these claims. As Mike pointed out, and you may have seen that the Black Lung Benefits Program services more than 47,000 beneficiaries, and they pay out well over $200 million a year, although they have an award rate overall of 15%, so about 85% of the claims are eventually denied. And that's fairly consistent through fiscal year 2013, the most recent data we have, about the 85% denial rate. In that 2009 report, the GAO made some suggestions for the Department of Labor to improve the program, improve representation for minors. I don't know that we've taken advantage of those recommendations in terms of helping provide representation. I know that the congressional delegations from Pennsylvania and West Virginia are concerned about representation and asking for some ideas on how to handle that. Of course, one of the biggest changes that Mr. Chance referred to was the Byrd, Senator Byrd law on the PPACA, which created the presumption concerning the existence of coal workers' pneumoconiosis and death or disability causation for those minors who have a total respiratory disability and can establish 15 years of, or is it 10? 15 years of underground coal mine employment. And that has helped a little bit, I would say, in the processing. I was looking at your statistics on your website, since we didn't have them, and it looked like in fiscal year 2013, around 600 survivors' claims were automatically awarded. So the PPACA provided, for those of you who don't know, if the minor had been awarded lifetime benefits in his black lung claim, the survivor doesn't have to prove anything. She just files and has an automatic award of benefits. So that took away 600 cases that we might otherwise have to write decisions on. So that was a tremendous improvement. Now, we've also tried to, in terms of representation, I know when I started, I was young and naive. I was 10, unlike some of the other speakers, a little bit older. Idealistic young judge in the beginning of 1997, I tried to talk the West Virginia Law School into representing black lung clients, and that sure didn't work out too well. They had their own clinical program. More recently, we've touched bases with other law schools in the region in Pennsylvania, and I can't say they've had much interest in representing clients. So it would be helpful, perhaps, if some of the other clinics in your organization might provide a lay representative. I suppose we could use some in West Virginia, where the number of black lung lawyers seems to be declining. I mean, we have our experts like Mr. Foreman, who's in the audience here today, who's been around for, you started when you were about 3, didn't you? About 3 years old. So, and he's semi-retired now, so eventually I suspect he'll be hanging up his black lung spurs. We do have new people coming on board, and I still kind of see Mr. Klein as being one of the newer people, because I remember when he was a lay rep doing cases, and he's just developed into just an outstanding black lung lawyer, and certainly has brought some important issues to the forefront that everybody is trying to look at now. According to the Department of Labor, about 80% of all claims decided at the district director level don't have any further action after that. They're not appealed, about 80% of them. About, and this is no surprise, about 80% of employers, the mining companies who lose cases, they appeal. 15% of minors appeal. So there's a real imbalance there on cases that are appealed that come to OALJ. The Benefits Review Board pointed out that between 2004 and 2008, about 43% of the cases that were decided at the OALJ level went up to the Benefits Review Board, and they get to have their say on those appeals. And then only 10% of Benefits Review Board cases go to the various circuit courts of appeal, and that depends what part of the country you live in, which circuit court that you go to. And each one of them has a little bit different spin on black lung law. Judge Caldwell wanted me to let you know, I guess we're airing our dirty laundry here, that right now we have 1,860 unassigned black lung cases. And those are cases where claims have come up to us from OWCP, whether awarded or denied, that haven't been assigned to a judge, 1,860. And it's taking about 450 days from the date a claim is filed until it's assigned to one of our ALJs. The Department of Labor, the OALJ has a performance goal, surprisingly, that they'd like to see 80% of all of our decisions and orders issued within 365 days of getting the hearing transcript. And usually the hearing transcript comes in sometimes around 30 to 60 days after the hearing. And then we usually wait another 30 days or so to get legal briefs, and we want to hear from the lawyers or the representatives before we write a decision. In Pittsburgh, the situation is much better, and I take it because my colleague, Judge Swank, who's sitting up here, that some of you may have met, is very productive, and I try to be productive as well. We have, between the two of us right now, 227 cases that are on our dockets, and some of you may want to know that we have a January and February docket coming out in Charleston, and where are you going? Yeah, he loves Wheeling, Morgantown, and Pittsburgh. So he's going to be doing a January, February docket of 25 cases. And the hearing notices will be coming out. Unassigned cases, we have 210 unassigned cases. We've decided so far this fiscal year 169 cases, and what that comes out to is about an average of 90 decisions, black lung decisions a year for each of us, Judge Swank and me. The average time for our decisions to come out is about 6 to 8 months after we have a hearing. My personal goal, and I've been slipping a little bit because of the volume, is to have a decision back to the minor or the survivor within 6 months of the hearing date. This is 2013, 2014. It's not the first time that there's been a big backlog in Department of Labor claims. That's been a historical problem at times, and oftentimes in order to resolve the backlogs, Congress has taken action. Some of the reasons for the backlog: when I joined OALJ in the beginning of 1997, again when I was 10 years old, we had 60 administrative law judges in our organization scattered throughout our 5 offices throughout the country. And each one of them had a law clerk. Today we're down to about 30. And some of our judges are sharing law clerks. And having attorney advisors and law clerks really amplifies the amount of work we're able to get out. They're smart, young, energetic people who give us the legal answers that we often need. In Pittsburgh in 97, we had 5 administrative law judges, each with a law clerk. And through retirements, attrition, now we're down to 2. So that's a big reason. We've lost the resources. I think some of the money that the Department of Labor has available has gone to other programs. So sometimes they have other priorities. The other thing that we tend to get siloed a little bit because you folks do black lung, but administrative law judges in labor do many other types of cases. For example, right now we have just an explosion of thousands of immigration cases that we're involved in doing. Fortunately, we only do a small amount of those in Pittsburgh. Judge Swank, for example, on his docket right now has 44 mine safety cases. So you're asking us, what do you do in mine safety cases? That's in our charter too. And we also have whistleblower cases that we do in the environmental, nuclear, and transportation fields. Right now, for all of our 30 OALJ judges, we have 343 whistleblower cases, and those are complex litigation with complex discovery issues and so on. The other problem we have, or another reason for maybe the backlog, is it takes a lot longer to write a black lung decision today. The law has become so complex. I know the attorneys who submit briefs and motions will sympathize with that. It's not a matter anymore where a young lawyer or an older lawyer can come in and just read the statute, the Black Lung Act, and read the regulations and figure, oh, this is easy and this is how it fits in, and write a decision or write a brief. You can't do that anymore because of the multiple decisions of the Benefits Review Board and many of the decisions of the circuit courts. It's writing a black lung decision now requires a lot of time and attention. There's been some statutory and regulatory changes that bog us down a little bit in terms of deciding cases. For instance, right now, Mike indicated we've got the new digital x-ray rule. So now Judge Swank and I and the other judges that do black lung are receiving many, many motions about how do these new rules apply. Because sadly, they didn't ask OALJ when they were writing the regulations for much input, and they didn't talk about to which claims and which x-rays, digital x-rays, does the new rule that was effective on May 19th of this year, to what x-rays does the rule apply? So now we have the issue about does it apply to only claims that were filed after the May 19th effective date? Does it apply to readings on or after May 19th? What about x-rays? So we have lots of motions and issues there. And the other issue that bogs us down and creates a little bit of a backlog is the Benefits Review Board. They have a proclivity to send cases back when they're appealed, and the last year for which I have a statistic was unfortunately 2008. They remanded 43% of the cases that came to them back for a redo, and that's very difficult and time-consuming. We believe anecdotally that the number of remands from the Benefits Review Board has declined, but they haven't given us those statistics just yet. As far as solutions, again, you know, I'm from the government, and the government solution to most things is we need more money. So the Department of Labor is supporting our request, and the congressional delegations from West Virginia and Pennsylvania to have, I've heard, up to $10 million to hire at least 10 new administrative law judges that would help get us up to speed, and law clerks. In Pittsburgh, if a budget is passed, an appropriation for the Department of Labor, we could get two new ALJs and one new law clerk. Now, as Mike pointed out, it looks like we're going to have a continuing resolution again, at least through December 15th, and then probably another one. So in that case, we're not going to be able to hire anybody. One good piece of news we have is that we have a retired ALJ that we're bringing back half-time starting in October. He will be exclusively working on black lung claims. So that should help us get some of those decisions out. We also had a review by the Department of Labor Inspector General's office, and they went to our black lung offices throughout the country and got input from the judges and the staff and looked at our data and paperwork. And hopefully they'll come back with some recommendations. My feeling was that they were there to try to help us and come up with efficiencies and ideas where we could process these claims a little bit faster, such as digitizing records, and we're behind on that. One of the good things that came out of the IG review was an effort by OALJ to send the judges' top 10 medical questions over to NIOSH to get some answers on these medical questions. that we have. One of the questions dealt with, the standards on arterial blood gases are not quite as stringent as on pulmonary function studies. How many times do you exercise a minor? How do those best work? So the judges are asking some medical questions. If we get answers from NIOSH, then hopefully we can adopt those and refer to those in our decisions. Now, I see I'm kind of running out of time, cutting into my intellectual future law professor's time, so I'm going to let attorney advisor Frank Fragan come up, and he's going to provide a challenging discussion related to the problems that surfaced in the Gary Fox case. Sorry for taking so much time for you.
Thank you, Judge Morgan, and thank you, conference organizers, for this opportunity to speak to you all today. I guess it always falls to the youngest person to squeeze in a 20-minute talk in 10 minutes. Yeah? Okay. All right, well, we'll see what we can do. My talk in a nutshell is about the case of Gary Fox. And I guess my conclusion, I'll come right out with it since I only have about 8 minutes, is that the problem in the Fox case and cases like it wasn't that Fox didn't have evidence. The problem in the Fox case and cases like it was that Fox didn't have counsel. And I think if we understand that to be truly the problem, then the proposed reforms and the perspective on the proposed reforms changes shape. So instead of focusing on changing the rules of discovery, where we would force parties to exchange evidence that they develop in their own cases, we would instead focus on changing the incentives to bring more representatives to take on cases like Fox and provide adequate representatives or incentives to those representatives. So let me indulge and speak briefly on the facts of the case, which I'm sure most of you know. Fox appeared in 1999 pro se, and he lost. The employer at that time had developed pathology evidence of its own, which had shown that Fox suffered from complicated pneumoconiosis. However, the employer didn't provide that pathology evidence to its own experts. Its own experts ended up developing opinion based on, I guess, an incomplete clinical picture of Fox, and they opined that he had neither simple nor complicated pneumoconiosis, and presented those opinions and that information to ALJ Burke. Or no, I guess it was a different ALJ at that time. ALJ Burke took the case later. But in any case, they presented it to an ALJ. Fox lost. He continued working until 2006, and then he filed a second claim, but this time with the help of counsel. And that time he won. And not only did he win, but he was able to show that the employer had known that he had complicated pneumoconiosis in 2000. And thereafter, he tragically died. So his wife continued his claim, and he went before ALJ Burke, and ALJ Burke found that there was fraud on the court. Well, it was appealed. It went to the Benefits Review Board, and the Benefits Review Board said, well, no, there wasn't fraud on the court. And the reason why is because there was no bribery of a judge, there was no bribery of a juror, and there was no improper influence on the court that was exerted by an attorney. And the Benefits Review Board even said that even if there were perjury, that is, lying to the court under oath, or fabrication of evidence, that still would not suffice to reach the level of fraud under the court under United States Supreme Court precedent. Well, the case went up to the Fourth Circuit. The Fourth Circuit said the same thing, and it articulated the same rationale for the holding. So quite naturally, this gave rise to calls for reform. And unfortunately, the calls for reform have been focused on changing the rules of discovery. And the theory goes that if we were to force the employer to turn over the evidence that it had developed and that had shown that Fox had complicated pneumoconiosis, if we were to force the employer to turn over that evidence, then we would maximize accuracy of the decision. The ALJ would have all of this information at its disposal, and we'd be able to anchor the decision in the remedial purpose of the Act, which is a preference for accuracy, and to provide benefits to minors who actually suffer from black lung disease. Well, there's a problem with this reform and the idea behind it. And I think our thoughts about reform in this direction are reliant on a false assumption. And that false assumption is that if employers are forced to turn over evidence, they'll continue to gather evidence in the same way. Well, that's just not true. If employers are forced to turn over evidence, they're going to gather it undoubtedly in a different way. So, for example, perhaps they'll verbally screen with a telephone call their experts before asking that expert to write a report. I recall that changes to the evidentiary limitations in the early 2000s were supposed to level the playing field then. But a large volume of evidence still comes in through medical records, catch-all categories of other evidence, serial filings of supplemental reports, of supplemental reports, of supplemental reports. So we have to think, will this type of remedial solution, changing the discovery rules that is, will that suffice inside of the adversarial system, which is black lung benefits law? So that's my first question for you all today, is that will a remedial solution suffice inside of an adversarial system? Now, even if we could design the perfect discovery rule, okay, the perfect discovery rule being that we come up with this perfect rule which doesn't change employers' incentives. They go out and gather information and evidence in the same way, and then they turn it all over to the other party, and they turn it all in front of the court, and we have this most accurate, perfect clinical presentation before the ALJ, and we're able to make this perfect, accurate decision. Even if we were able to design such a rule, is evidence disclosure really the problem? Would it solve the problem? Would it solve the Fox evidentiary problem? For example, the West Virginia Occupational Pneumoconiosis Board, in the case of Fox, they diagnosed Fox with progressive massive fibrosis as early as 1997. Okay, there was evidence that Fox held that he had complicated pneumoconiosis 2 years before he filed his claim to the district director. Now, if Fox had counsel that first time in 1999, if he had a representative, the representative would have done three things. First, they would have known that the Occupational Pneumoconiosis Board found evidence of complicated pneumoconiosis. Second, they would have known that the employer had not produced pathology evidence. And third, the representative would have known that employers' reliance on a single autopsy report diagnosing a pseudotumor was therefore questionable. Now, the Fourth Circuit said as much in its Fox decision, and I'd like to read a short excerpt from it, and I'll be within time. I guess that was funny. All right. So the ALJ recognized, and this is the Fourth Circuit I'm reading, the ALJ recognized that Elk Run's, this is ALJ Burke, that Elk Run's case in the 1999 claim was vulnerable when it found that Elk Run built its case around Dr. Koh's single pathology report. And then the Fourth Circuit says, however, Fox had the right to cross-examine Dr. Koh regarding his qualifications and conclusions. Fox had the right to cross-examine Elk Run's other experts to test their understanding of and reliance on Dr. Koh's report. Fox had the right to question the apparent lack of additional pathology reports. Fox had the right to question, or the right to present his own contradictory medical opinion from a pathologist of his own choosing. Well, I don't know about you all, but I think what the Fourth Circuit failed to recognize is, well, Fox may have had those rights, but he certainly didn't have the capability. Okay, Fox had the right to cross-examine Dr. Koh regarding his qualifications and conclusions, Clearly, he didn't have the capability. Indeed, he probably didn't even know that questioning those qualifications and conclusions would discredit Dr. Coe and help his case. Okay, Fox had the right to question the apparent lack of additional pathology reports. Well, he didn't have the capability to realize that, there's a possibility that there could be some holes in his case because the pathology report only talked about a pseudotumor and didn't mention complicated pneumoconiosis. Well, the point is that if Fox had had counsel, and if others like him have counsel, they very likely, and Fox would have very likely, produced his own pathology evidence, which employer would have, I would add, have been unable to successfully rebut because its own experts knew that he had complicated pneumoconiosis. In short, Fox would have won his case. So the problem isn't that Fox didn't have the evidence. Indeed, he knew that he had complicated pneumoconiosis in 1997 from the West Virginia Occupational Board. Okay? The problem was that he didn't have the evidence. The problem was that he didn't have counsel. And when we understand this to be the true problem here, then our perspective on how reform should take shape changes. So instead of focusing on changing discovery rules, we focus on changing incentives for claimants' representatives. Now, what would those types of changes look like? Well, I don't know. I mean, this is certainly what we should begin to be thinking about. Perhaps paying out attorney fees at the ALJ level. Perhaps a flat fee for victory at the ALJ level that comes from the trust fund and cannot be revoked, even though the minor loses on appeal at the Benefits Review Board. Other avenues along these lines should be explored. In any case, the Fox evidentiary problem is an inaccurate picture of the real problem. The real problem was that Fox lacked counsel to help him pursue his claim. Reform should therefore focus on increasing incentives for representing black lung claimants and not on changing the rules of evidence that experienced representatives can already navigate, as Fox finally did in 2006. That's my talk. Thank you.
I said that I take issue with his idea that this can be solved with more representation because the discovery process takes a huge amount of work, both from lawyers and from judges, that would just jam up the system even more. And it's forgetting about, in my opinion, the fact that the whole reason this program exists is to protect the health and safety of minors, not to play games with medical evidence. Now, maybe there needs to be a diverse approach to how you fix this, but I don't think just more lawyers is going to solve it.
Well,
and the idea that an employer, if you're working in a law firm where there's a known health risk and your employer can withhold evidence that you have an advanced case of that disease, you've got a problem.
Yeah. I appreciate the comment, and I think we all do, but that's really the heart of my talk. I think that there's a tension between what we think that this program's designed for, which is a remedial solution, which is providing benefits to minors who are afflicted with black lung disease, and what it actually is, in fact, the way that Congress wrote the Black Lung Benefits Act. It's an adversarial system. It involves lawyers like yourself. It involves judges. It involves discovery, as you point out. It's complicated. If it were a pure remedial system, then a remedial solution would work. But it's not. It's an adversarial system, and that's why I think if we're going to focus on reform, if we have employers begin to turn over evidence, they're going to find other ways around it, the same way that they were able to find ways around the 2001 or the early evidentiary limitation reforms. So I think, unfortunately, we're in a second best case of a universe of opportunities, right? So the first best case, you might be very well right. The first best case might be to turn over evidence and to have everything be remedial, and to have, instead of judges and lawyers, we just simply have doctors who are able to know if benefits are warranted. But because we don't exist in that first best case universe, we have to, and we're trapped inside of this adversarial system. And solutions inside of an adversarial system are adversarial in nature. remedial solutions inside of an adversarial system, they don't match well. And I think that if we focus on trying to change the rules of discovery, and instead, because indeed, if Fox would have had a lawyer in 1999, I think the situation would have turned out a little bit differently. And if we focus on trying to find ways to incentivize representatives to take on cases, to perhaps pay them out at the ALJ level, or to perhaps offer a flat fee if they win at the ALJ level, and then they don't go on, or if they do go on at the Benefits Review Board and lose, they still get to keep that fee because it's paid out of the trust fund, for example. I don't know. I'm just brainstorming here, and I think that's where we need to be thinking.
Okay. We'll take one more question.
I think you'll make a good law professor because I think you're dealing in the realm of the ideal. The actual situation involves the need for both reforms that we're talking about here, both incentivizing more people to represent and cleaning up the cheating that's going on in the present system. As a practical matter, those of us who've worked in this for 30-some years have tried to get more and more people to represent claimants, and it's a very difficult thing to do because it isn't as remunerative as the other alternatives, so that your notion of incentivizing is clearly the case. It's a good idea. It should happen. We've supported it for a long period of time. But to think that there won't be a pushback realistically on the political side to make that difficult is to be unrealistic and not to look at the history of this particular program. So I do think that in and of itself is an ideal solution, but not a practical solution in and of itself. The notion that we can cut down on cheating on the margin, which is what the evidentiary rule is about, I think is a valuable one as well, because anytime you're trying to get political and societal support for any kind of reform, you have to expose. That's an element of the process in which you get change. That's how change happens. And this kind of exposure that's happened in this particular claim, Fox and the others, has been valuable to incentivizing Congress and the administration to deal with a problem that was long ignored. So I think if you look at the real way in which reform happens, you have to have both.
Yeah, perhaps both would be good, but again, I would caution that if we focus on discovery reforms, there will always be ways around it because we're still inside of an adversarial system. Thank you.